Yes.
Perfect. Okay. My name is Reinout from Malenstein, and I will be talking about intellectual property in China today. I work for a Chinese law firm, HFG, and we both do registrations of IP as well as litigations. That's all about us. I don't want to bore you too much about what lawyers do. What I do want to tell you is that you can actually protect intellectual property in China, which is very different from what you often read in the newspapers and hear on the news. One of the pillars of the US-China trade war was built upon IP problematics. So why can you register and protect IP in China, and why does the mass media tell you that you can't? Often, with some exceptions, it's about registration. So the problem is that most companies that are from the Netherlands are not protected in China because they simply did not register either their trademarks, their patents, or their design rights. And these kind of rights, you need to register domestically in China. If you do not do that, you have zero protection. And so often the stories you read in the media regarding Apple or regarding Jaguar Land Rover, the sad story is they actually didn't protect it in the right way. And obviously there are some exceptions, but the biggest problem really is companies not registering the rights. If you want the rights, you need to register them locally in China. So that's one. Now, a lot of companies always say, Reinout, I don't have any business in China. I don't plan on opening up a company there, so I don't need any IP protection. Still, in those kind of cases, I advise companies to do register IP in China for the very simple reason that China is the factory of the world. And unfortunately, that also goes for the factory of the world for fake products. And then you can also go further on that by saying, wait a minute, if you didn't register your rights in China and a Chinese company is manufacturing in China, there is no IP infringement because your rights are not protected there, which means you can freely use those rights. So my point that I would like to make to Europeans and Americans, in this case to you as Dutch businessmen and women, is register your IP. If you don't do business in China yet, you definitely want to make sure that the Chinese don't use your hard labor and fruits and then put it all over the world, all these infringements, because then you have to battle in all these countries. Whereas what you want to do is you want to have a baseball bat and you start smacking on Chinese factories and close them down. And the only way you're going to do that realistically is by having IP rights protected in China, so you can take the problem down at the source and close down the Chinese factories, which you can actually do with IP rights. So when we talk about IP rights, there are various rights. So I'm going to talk you through all the IP rights and also trade secrets, because I noticed that the level of understanding of China and IP is very different for each of your companies. So that's why I will be keeping it general. And if you have any broader questions later or more specific, feel free to ask. Now, trademarks, first of all, I know you're all in the biopharma industry and that patents are very important, but it's also very important to have your name and your product name protected. Why? For the very simple reason that if you don't protect it and someone else registers it, then that person, that company looks like it is you, but it isn't. So that can have massive negative consequences for your company worldwide by having a Chinese company that has the name rights or the symbol registered in China. So with this, think about words, logos, numbers, color combinations, 3D symbols, and even sounds like tan, ta 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 tan. That's the Intel sound, for example. So all of these things, like the Apple logo, the McDonald's logo, just do it, a slogan from Nike, can be registered. I usually advise companies to at least register 3 types of trademarks, which is 1, your Dutch or English name, 2, your logo, 3, the Chinese name of your company. And then most companies from the Netherlands ask me, Reinout, what are you talking about? We don't have a Chinese name. In that case, make a name for your Chinese company. And I will shortly tell you how to do that. Because the biggest problem with trademarks is actually that most of the time your trademark is already registered in China by a Chinese company. This is the number one problem that companies face in China with regard to trademarks. However, good news, you can get it back under a few circumstances. So if there's some kind of business relationship with that company, you met this company on a trade fair, well, probably during COVID, no trade fairs, but let's say like you have an email correspondence with that company. If that company then registers your trademark, that's called a bad faith trademark application, and you can get back your trademark. Also, if they steal your logo, apply for that. You can use the copyright of your logo to get it back with the China Intellectual Property Agency. Nowadays, there's also companies that file like more than 30 or 50 or even like hundreds of trademarks. Then you can also get them back, because the China Intellectual Property Agency does not see such use as serious. It sees it as going outside the usual demand for a company. So those are the reasons normally to get it back. And if you're really big, you're an Apple or a Nike or Coca-Cola, you can also get it back stating that you're a well-known trademark. But with your companies, unfortunately, we're not there yet. So that wouldn't be a way to get it back. Now, how to register it? You can register it internationally or locally in China. I would highly recommend locally in China for the simple reason that the international system is different from the local system. Local system has subclasses. So there's 45 classes of goods and services, and the Chinese have made the system more complicated by dividing those further into subclasses. So to give you an example, if you have the subclass of clothing, a dress and a wedding dress will be two different subclasses. So if you're Armani or Gucci and you have registered dresses, you expect to also get protection for wedding dresses, but that's a different subclass. So a Chinese company can come in and claim that subclass. So you need to be very specific. So that's what I'm saying. Like what we often do is if a company wants to register something, we do a free of charge filing proposal and we tell like, okay, we recommend this and this and this, see your business. That's very important. And through an international registration, you cannot get the same kind of protection. So please check the subclasses. Nowadays, it actually takes around 6 to 9 months locally to get a trademark. So that process has been speeded up. So that's good news. And now it comes. We're talking about an example in your industry. Why get a Chinese trademark? Well, there's a company called Pfizer. I'm pretty sure every one of you knows that thanks to COVID. Probably before that, Pfizer was already very well known too. And Pfizer thought, okay, we're going to launch the Viagra drug in China. That will be a great success. So with the question of, do we need a Chinese name? The answer was no, we're Pfizer, we're number one, kind of like the Ajax mentality. We don't need that. We're going to just put Viagra on the market under the name Viagra. So nice trademark, Viagra registered. What happens? Chinese people speak Chinese. This sounds very basic, but it's a fact. So 1.4 billion people, they use Chinese, not English, to communicate. Hence, they wouldn't talk with each other like saying like, hey, Germany, Yongbyon, the Viagra. That's not going to happen. The Viagra is a very unpronounceable word in Chinese. So what happened is the local market created a name for this drug, which is Weige, Big Brother. And there was a very smart Chinese company also in the same sector that registered that name. And then the problem of Pfizer really came to be, which is people would want to have the Weige drug and not the Viagra drug, because Viagra is known in China as Weige. So for that simple reason, please make a Chinese name, register it, own it. Next question, how to do that? There's 3 ways of doing it, or actually 4 ways. Like one is you translate the sound. So Maidanlao is McDonald's in Chinese, Ferrari in Chinese. That's a good way of doing it. Also, you can translate the meaning. And so apple, 苹果 is literally the same apple as we're talking about in English. That's a good way to do it too. But you can also mix it, mix the sound with a great meaning. And one of my favorite examples is Coca-Cola with Coca-Cola, delicious happiness. And for a sugar drink, that's a pretty amazing name. Or Bauma, precious horse, for BMW. which is also often referred to as Beamer in the US. So also a great name. So make a name. And sometimes when it really doesn't work for you, for example, Reinout from Malenstein doesn't work in Chinese. And it doesn't work with sound, doesn't work with meaning, mixing also doesn't work. So what did I do? My Chinese name for the past 15 years has been Wang Reining. Completely different, has nothing to do with it. That's also a way to do it. Now, important for all your companies, when you're thinking about patents, is patent in China. Get those patent protections in. So you have the invention patent for new inventive and industrially applicable inventions. You have the utility model patent for more the gebruiksoctrooi, how we used to have that in the Netherlands, and Germany also still has that for patents that are less inventive. And the design patents, which fall under the design right law in the EU. So that's where China put the design rights under the patent law, with massive consequences for new and creative designs. Now, you have to apply with CNIPA. You have 10-year protection for the utility model patent and 15, I should change this in the slides, for the design patent, because the law has changed, and 20 years of protection for the invention patent. So like trademarks, this is a monopoly right. You have the name of the trademark, that is yours forever, unless you start forgetting to pay the renewal fees. And with patents, you have it for this limited time, 10 years, 15 years, or 20 years. You need a Chinese patent agent. Make sure your translation is correct. Don't just put it into Google Translate or Bing Translate, or let a translation agency do it. No, let a patent attorney that can speak English and Chinese fluently really make sure that the patent in Dutch and English is the same as in Chinese language. That's crucial, because that's where even the big multinationals lose in court, because the judge will say like, well, you claim to have this, the patent says this, that's different. And then they say, well, look at their international application. And then the judge says, no, I need to look at your Chinese application. So make sure the translation is correct. And also make sure that you keep your patents new, meaning you keep it disclosed, you don't show it to anyone, you keep it safe and sound, and then you put in the application. Once the application is filed, you can share it with the world. If you share it before that, you cannot protect it anymore, because the patent would not be new anymore. So that's a case what happens to the bus of the MAN company Neoplan on the left, and you have a Chinese bus on the right, very identical. The Germans had the design patent, went to court, and they won the case for patent infringement. So the Chinese had to pay. But the Chinese, they know the law, and they thought like, okay, we need to find this bus in the publication before their patent was applied for. And indeed, they found that bus in the magazine Bus Magazine and Bus Aktuell, both German bus magazines, for your information. So that's also the reason that this bus is still around in China now. Make sure, long story short, that you keep your patents safe. Also meaning, if you deal with Chinese people, who doesn't matter who, you need to have non-disclosure agreements, and you rather not share like too much information regarding it. Anyways, we get to that later. Interesting for you also is to know that copyright in China is protected as the expression of an idea. Same thing in the Netherlands. It exists the moment you make it. So for your website, for your packaging, software, images, you all have copyright on that. However, I highly say to you, please register your copyright in China. Why? You get a copyright certificate. It turns around the burden of proof. So you don't have to prove that you're the owner anymore. You are the owner because you have a certificate, and now the other party has to prove that you're not, which obviously is very difficult if you have this certificate. So for important copyright, please register it with the China Copyright Bureau. Now, what I also encourage all of you to do is to have a look on Alibaba platforms, Jingdong platforms, and other e-commerce platforms to see if you're being copied at the moment. That is always good to know, especially in biopharma, because it could be very dangerous, obviously, if a product is not that the customers believe it is. And so with these platforms, have a look. put in your name, see what you find. And if you find anything that's not yours, get notarized evidence in China of the web pages, because only notarized evidence can be used in China in order to win a case against a company. We get to the last topic, which is trade secrets. I taught you already earlier with regard to patents, keep it disclosed. Don't share it. All this information like processes, methods, recipes, marketing strategies, customer information, with trade secrets, people often think about the Coca-Cola recipe. That needs to be kept secret. And in accordance with Chinese law, you need to keep it secret by physical measures, technological measures, and contractual measures. Physical means I come to your office, there's someone at the reception stopping me, I can't just freely browse around. Technological means software protection on computers, etc., passwords. Contractual means NDA. When you do business in China, you need non-disclosure agreements, and good ones that are actually effective. If you use often NDAs with a Chinese party that's not in the Netherlands, and you put in Dutch law applicable, it's very hard to enforce that in China. So you need to specifically look per contract, what kind of contract do I need with this party. If all goes well, then you can enforce it in court. For example, Eli Lilly, another big pharmaceutical giant, enforced successfully against Huang their trade secret. So Huang was a researcher that started downloading all this information that was not supposed to be downloaded, was confronted to it by IT, and said to IT, I'm leaving, bye-bye. Immediately, Eli Lilly contacted their lawyer, and their lawyer made sure that since Eli Lilly had the physical measures, technological measures, and contractual measures in place, that this person was not allowed to disclose the trade secrets in any way. So that's important when the shit hits the fan, to make sure that you immediately take action. And when we're talking about taking action, my last point that I want to make is lawyers always say, start writing letters to a company to stop, or do this or do that. Actually, in China, there's step one and step two. And step one is the most important thing, which is get notarized evidence in China by a Chinese notary public of the infringement on your rights. Once you have that, you can look at step two, because the chance that you win step two, which is administrative enforcement, litigation at course, or the criminal prosecution, is very high once you have the right evidence. So get your evidence straightened forward through notarization, and then think about step two. So that's it from my side. Looking forward to the Q&A, and looking forward to also hopefully seeing you one day here in Shanghai if you come over. So thank you very much.
Thank you very much, Reinout,